Uh, Good afternoon, everybody, and welcome to the webinar. I think it is now past 1 o'clock, so we are going to make a start. Thank you for joining us today. Our webinar topic today is the Child Safe Standards and Reportable Conduct Scheme. To keep things running smoothly, today we've turned off the picture and sound for all of the participants who have dialed in. We do have a Q&A function running, so you are welcome to post a question or a comment anytime into the Q&A, and we have moderators who are monitoring that for us. We are also going to have a dedicated Q&A session at the end of today's presentation. I invite you right now to share into the Q&A what sector you're here from, so that we can get a bit of a sense of who's online today. You don't have to identify your organisation, just the sector. I will also note that we are recording today's session, and we may provide this recording up on our website or out to participants at a later stage. If you would like a copy of the slides from today, you can contact us at the end and we will get those emailed out. And if you do have any issues with the recording in terms of having your name or your details potentially published publicly, please do contact our team and we will make sure that we can protect your privacy. So before we get started, I do wish to make an acknowledgement of country. So I wish to acknowledge the traditional custodians of the lands, which for me is the Ngunnawal people, and pay my respects to elders past and present. I also acknowledge the emerging leadership capacity of First Nations children and young people, and the importance of culture in giving their lives strength and meaning. I also acknowledge the enduring connection to country of all Aboriginal and Torres Strait Islander people and the ongoing impacts of dispossession and colonisation, recognising that their rights to these lands have never been ceded. I would also like to acknowledge the survivors of childhood abuse, including the adults, children and young people who have experienced harm in all its forms by those who were supposed to protect them. I recognise the courage of survivors of institutional sexual abuse who shared their experiences with the Royal Commission into Institutional Responses to Child Sexual Abuse, with the hope that all children will be protected, believed and safe in the future. Reportable Conduct Scheme and the Child Safe Standards both have their origins in the Royal Commission. So it's important for us to honour today their courage in coming forward and remember that the schemes that we talk about today are not just regulatory, brainchilds. They are there to protect children from real harm that has occurred and continues to occur in institutions. So, some introductions to kick us off. My name is Gemma Rowe and I'm the Senior Capability Development Officer working on the Child Safe Standards at the ACT Human Rights Commission. With me today online is Jeffrey Alexander from the ACT Ombudsman, who will be presenting on the Reportable Conduct Scheme. So our contact details are up on the screen, but don't stress because we are going to share them again at the end. And we welcome you to reach out to us if you've got any questions or you need further support in implementing child safe standards or reportable conduct in your organisation. So today we're going to cover the regulatory frameworks for child safe standards and reportable conduct. We're going to do a very brief overview and recap of the standards. And then we're going to hand over to Jeff, who will do coverage of the Reportable Conduct Scheme, including the obligations for organisations and how they intersect with the Child Safe Standards. And we will, as always, finish with a few practical actions that your organisation can think about taking. As I said, we will also have dedicated time for Q&A at the end. Okay, so just to start off, we've got a brief timeline and an overview of the legislative requirements for child's rights, safety and wellbeing here in the ACT. So these form what we call the protective framework to prevent harm to children and other vulnerable people. So in 2004, the Human Rights Act was introduced, and in 2008, the Children and Young People Act was introduced, which superseded previous acts, the Children's Services Act and the Children and Young People Act from 1999. These two key laws, Human Rights Act and Children and Young People Act, cement into legislation key requirements in relation to protecting children's rights and promoting and protecting the safety and well-being of children and young people. They also include the idea of decision-making and the best interest of the child. So then in this early 2000s, there was also increasing public scrutiny about the problem of childhood sexual abuse in institutional context. So this led to two key things. Firstly, the development of worker screening programs. So here in the ACT, that's the Working with Vulnerable People scheme, which came into force in 2012. And this increasing scrutiny also led to the Royal Commission, which I referenced earlier. So the Royal Commission into Institutional Responses to Child Sexual Abuse was announced in 2012 and it ran all the way through until 2017. It heard from thousands of survivors of childhood sexual abuse and it found that more needed to be done to prevent and protect children from abuse within institutions. The Royal Commission made over 400 recommendations on how to improve laws, policies and institutional practices to prevent and respond to child abuse. So, among those laws and policies and changes was the Reportable Conduct scheme, which here in the ACT was introduced in 2017. And then the Child Safe Standards, which got introduced in 2024. So both of those link directly back to the Royal Commission. Reportable Conduct aims to ensure that organisations working with children report allegations of child abuse and misconduct to an oversight body, which of course is who we have online today. And it also requires organisations to have procedures for handling complaints and allegations related to child abuse. And then the Child Safe Standards, which is the newest kind of piece of the puzzle. They aim to prevent harm and create an organisational culture and practice that promote and protect rights, safety and well-being of children and young people. So that's a very brief overview of all of the pieces of legislation, or some of the pieces, and unfortunately here in the ACT all of those pieces are administered by different organisations. So it's a complicated space with a number of agencies involved. So for the Child Safe Standards, that is being led by the Children and Young People Commissioner, who is part of the ACT Human Rights Commission. The Reportable Conduct scheme, which is what we're looking at today, is administered by the ACT Ombudsman. And then Working with Vulnerable People is delivered by Access Canberra. ACT Children, Youth and Families are responsible for implementing Children and Young People Act, which is those child protection matters, and also child safe reporting, which many of you will be familiar with in an organisational context as things like mandatory and voluntary reporting. Of course, where a concern relates to child sexual abuse, it should also always be reported to ACT Police. We're not going to cover too much today or anything further today about working with vulnerable people or mandatory reporting, but it is important that you understand that these are key pieces of that protective framework. I do also want to just note, particularly for those organisations who are in scope for the Reportable Conduct scheme, that you likely also have your own sector regulators. So, for example, Seeker for education, and of course, health practitioners and the out-of-home care sector have their own regulators as well. So they also often have requirements for child safety. So it is all working together with the aim of keeping children safe. All right, so as I said, today is about reportable conduct and child safe standards, and we're in particular looking at the similarities as well as the differences. So the child safe standards apply to all organisations that provide services to children and young people. So this means that if you're working with children in any way, you are required under legislation to implement the standards. Staff and volunteers need to support the implementation of the standards, but it is primarily an obligation that applies at the organisational level. Now, in contrast, the Reportable Conduct scheme has a narrower scope, and it only applies to certain organisations, which are known as designated entities. So Jeff will take you through what this means and what a designated entity is a little bit later. But at this point, it's just important to note that reportable conduct doesn't apply to all organisations here in the ACT. Reportable conduct is about keeping children and young people safe, and it has got a focus on building capability of organisations to prevent and respond to those allegations of abuse and harm. So a brief recap now on the ACT Child Safe Standards. So the standards, there are 10 of them, and they are up on your screen at the moment. They were introduced on 1 August 2024. So these standards apply to any organisation that is providing services for children and young people, and we define that as anyone under the age of 18 years. So it's very broad as a scope, and the standards apply to those organisational practices by staff. So they're separate from abuse and harm that might be occurring elsewhere in a child's life, for example, in their home environment or in their community. There are separate obligations for that, but the standards is about how your employees and your volunteers are treating children and the practices that you have in place in your organisation. So I guess in terms of what does that mean? As I said, it is really an organisational obligation. So it's got a huge focus on culture, and the standards themselves range from things like having strong leadership and governance, having policies and procedures, making sure that we're clear about our practices for interacting and engaging with children. We're thinking about our staff, our screening and our training, and of course the reporting and investigating mechanisms for concerns. Later on in the presentation, we will touch a bit more on some key standards that, kind of intersect with the reportable conduct scheme. So we always like to include this slide in our webinars, and that is because this is a definition that came from the Royal Commission. So ultimately, the intent of the Child Safe Standards is to guide organisations to be a child safe organisation. Now, a child safe organisation is defined as doing 3 key things. Firstly, it creates a culture and environment where children and young people's safety and well-being is at the centre of thoughts, values and actions. So this is that mindset of putting children's well-being at the centre of your decision making. Secondly, a child safe organisation is one that places genuine engagement places genuine emphasis on engagement with and valuing of children and young people. So that's that consultation element, making sure that our children and young people have their voices heard. And thirdly, a child safe organisation is one that creates conditions that reduce the likelihood of harm, increase the likelihood that harm gets identified, and responds appropriately when concerns or allegations or suspicions of harm are raised. All right, I'm now going to hand over to Jeff, who will take you through the reportable conduct scheme.
Thank you, Gemma, and good afternoon, everyone. I would like to echo the acknowledgement of country and also the acknowledgement of survivors of abuse. As Gemma mentioned, the Reportable Conduct Scheme was a Royal Commission recommendation, noting that at the time, New South Wales was the only scheme operating at the time. Reportable Conduct Schemes are now in place in most states, with Queensland being the latest state to have a Reportable Conduct Scheme, and this will be in place quite shortly on the 1st of July. The ACT scheme was based on the New South Wales model, as was the Victorian scheme that came into place about the same time. And as Gemma mentioned, the purpose of the scheme is to ensure allegations of ill treatment towards children are responded to appropriately via an investigation, and that there is oversight of the investigation and what actions have been taken. And that is the role of this office. And as noted, at the bottom of this slide, please note that the scheme does not replace reporting obligations to ACT policing or children, youth and families. Organisations covered by the scheme are referred to as designated entities. And on the left-hand side of this slide, you can see a list of designated entities as defined by the legislation, the Ombudsman Act 1989. This list loosely followed the New South Wales definitions of designated entities at the time. I'm aware that New South Wales has changed these definitions over time, whereas the ACT scheme has not changed. And I know we have a question later on in the Q&A section regarding the exclusion of, I think it's specifically sporting groups and private academies, but we can certainly answer that question more broadly when we get to that part of the webinar. And on the right-hand side, you can see there which organisations are not captured by the scheme. It's our understanding that sporting clubs do have a requirement to report some conduct to Sports Integrity Australia, but there still might be some gaps there for less serious allegations and how those are responded to and overseen. So who is captured by the scheme in terms of individuals? So the first dot point here is quite broad, but there is a distinction regarding employees as opposed to contractors and volunteers captured in the second dot point, in that contractors and volunteers need to have been engaged specifically to provide services to children. So, for example, if a designated entity hires a tradesperson to come on site to complete some work, they are not captured by the scheme as they have not been engaged to provide services to children. But, for example, if you engage an athletics coach to run a session with children, this person would be captured as they have been engaged specifically to provide services to children. And on that final dot point, the legislation does state that conduct in a person's private life is also captured by the scheme if that person is also defined as an employee. Religious bodies have a different definition of an employee in that it does capture contractors and volunteers, even if they are not engaged specifically to provide services to children. And the final dot point on that slide just reiterates the conduct in both professional and private capacity does fall under the scheme. It's also worth noting that religious bodies weren't brought into the scheme initially. I think they were brought in approximately 18 months after the inception of the scheme. We'll now take a look at what is reportable conduct. This gives an overview of what reportable conduct is with a mixture of references from the legislation and also our practice guide. And just note that middle dot point there, which refers specifically to offences against the Education and Care Service national law. That is specifically regarding some provisions in that legislation 166 and 167. Which can be problematic at times, and we're working with SEMTED regarding that particular aspect of the legislation. We'll now take a look at what a reportable conduct process looks like. Apologies if the image on the left is a bit small, but it is available as a practice guide on our website. But it does outline the process quite well. It starts with the allegation. Once the head of entity becomes aware of an allegation, they have 30 days to report to this office under Section 17G of the Ombudsman Act. The Ombudsman then receives that notification and provides feedback to the entity, and in that we will decide whether we oversight or monitor the investigation. Monitoring will be a slightly more involved process where we can request updates or certain pieces of information regarding the progress of an investigation. That might be an investigation plan, a risk assessment, or possibly to see copies of correspondence that have been sent to persons subject of allegation. to ensure that the allegations are procedurally fair in terms of how they've been described to the person subject of allegation. I noted that there is a 30-day requirement regarding notification to the Ombudsman. In terms of the provision of a Section 17J report, there is no legislated timeframe for that, apart from being done or being provided as soon as practicable after the investigation. Once this office receives that final report, we are obligated under Section 17J to assess the matter and determine if it was properly investigated and whether appropriate actions were taken. That process may involve our office going back to a designated entity to request further information, whether it might be to confirm the findings or seek some clarity on certain aspects of the investigation to allow us to determine if it was properly conducted. And at the end of that process, we would close the matter. So what are designated entities required to do under the scheme? As noted before, it is a legislative requirement that an allegation be reported to this office within 30 days of the head of entity becoming aware. And then apart from business as usual type engagement with this office around how the investigation is being handled, etc., there is also a legislative requirement that designated entities have policies and procedures in place for preventing reportable conduct, enabling reporting, dealing with reportable conduct allegations, and also for information sharing of reportable conduct information. Under 17F, this office can also request all of those documents and provide feedback to the designated entity regarding how effective they might be and where there might be room for improvement. And that final dot point there is just referencing the 17J requirement that an investigation report be required to be provided to this office. And in terms of what the Ombudsman is able to do under the Ombudsman Act, as mentioned before, we can monitor the policies and procedures of designated entities. We can also monitor investigations. We can conduct investigations under Section 17K into complaints or allegations of reportable conduct. We can share information, we can take complaints, and all of these are broadly captured by the legislation. But just in terms of sharing information, there are other acts that could also apply to ensuring that appropriate information sharing takes place, and that is primarily the Children and Young People Act of 2008, which includes Section 863, which includes some pretty broad information sharing powers, which this office uses and encourages designated entities to use as well. So we're going to look at a case study now. Just give you a moment to read through the 2 paragraphs. So this is not an unusual situation that we see coming to us in the reportable conduct scheme, and that you might have a situation that starts out as quite benign and with no necessary, mal or ill intent present, and then it evolves into something where there's a decision point for the employee. So here there's a decision point in this second paragraph where the employee makes a decision that they have made to engage with this young person outside the workplace. Instead of possibly referring that person back to someone who is actually not on leave, and indeed not inviting the young person to their house. So this would be an allegation of reportable conduct. in that the residential care provider is a designated entity. The person subject of the allegation is an employee of that designated entity. And the conduct could be described as misconduct of a sexual nature crossing professional boundaries. And as per our practice guide, while the conduct is not explicitly sexual, it does involve an inappropriate and overly personal, intimate relationship with a child or young person. Gemma, I might hand back to you for this section.
Okay, thank you very much, Jeff. That case study that was just provided is an excellent example of why the child safe standards are so important. And we are now going to take a little bit of a look into the standards and think about some of the things that we can do and key standards to help us meet those obligations under Reportable Conduct Scheme, and really touch on, I guess, that intersection point. So in that example, Jeff made a bit of a call out about professional boundaries. So we know that absolutely the child safe standards are about preventing harm and ensuring that your organisation is child safe. And standard 1 is one of the standards that has a really clear intersection with the Reportable Conduct Scheme. So under Standard 1, which is around our leadership, it's important that child safety is visible and that our leaders are communicating about child safety to staff. And this includes things like ensuring that there is a really robust code of conduct and that staff understand why there is a code of conduct and what their professional boundaries are. Because, as Jeff said, sometimes we see staff kind of ending up in situations where those boundaries get blurred and they may be making decisions which they believe to be in the best interest of the child or young person, but they're actually putting both the child and themselves at risk. Standard 1 is also important because, as Jeff mentioned a couple of slides back, the head of entity under Reportable Conduct has explicit obligations, of course, to prevent harm, but also around reporting. So making sure that as leaders, you are aware of those obligations and that there are procedures in place to make sure that you are meeting those legal obligations that you have. The next standard that has a really clear intersection for reportable conduct is Standard 6, which is about child safe complaints. So the things that you might look at doing is ensuring that information and ways to report concerns or, make a disclosure or, speak up about something that has happened. We want that to be really visible. And that's for children and young people themselves, parents and carers, and of course staff. It's very important that your own staff are empowered to speak up because they are often the ones that are most likely to be witnessing any conduct that might be inappropriate in your organisation. It's those colleagues and the day-to-day interactions. We need to make sure that there are robust policies and procedures into handling those concerns and allegations. So when somebody does speak up, is there a clear process for what happens next? And ensuring that all of those concerns and allegations get handled appropriately. So where we've got a good process, it means that it's not up to an individual to assess whether this is important enough for action to happen. Everything gets reviewed and actioned as they come in, and we're doing so with both procedural fairness, but also that sort of absence of bias that can come in if it's up to an individual to be making assessments. Of course, the reportable conduct scheme has an explicit requirement around, how you handle, having policies and procedures for handling complaints and allegations. So you do really need to make sure that you've got those processes written down if you are part of the reportable conduct scheme. Okay, so the next two standards that we're going to spotlight on are Standard 7 and Standard 10. So Standard 7 is about staff capability and training. So as an organisation, it is important to ensure that all of your staff are provided with information and training about child safety. And you should be doing this at induction and also often through, dedicated child safe training throughout their tenure of employment. To ensure that you're meeting your requirements under reportable conduct, you're going to need to also make sure that this includes explicit information about reportable conduct so that staff are aware about things like the need to report if something has occurred in their personal life. They know that they need to report that through to you as their employer under the reportable conduct scheme. And just generally so that staff are aware of what constitutes reportable conduct and what happens if a reportable conduct allegation is made, whether that's against themselves or another person. I guess Standard 7 also requires that we have that information available so that it's easy to find and it's easy to read. Staff know what is expected of them and they're able to go and find what they need in terms of, if they have a question or if they're not sure about, in particular conduct or something. As I said, in Standard 1, it's important to set those code of conduct expectations or professional boundaries, and Standard 7 is about that training element. So if you are an organisation that provides, direct services to children, I note today we've got lots from the early childhood sector online. It is important that those professional boundaries are talked about frequently. They are, discussed with staff and, staff are empowered to kind of ask questions if they're not sure how to do their job in a way that is upholding that code or professional standards. Standard 10 is about our policies and procedures. So reportable conduct requires you to have policies and procedures, and Standard 10 is about what you can do to make sure that those policies and procedures are practical, they're inclusive, and they're kind of regularly reviewed and updated. So we should be making sure that we're writing down our child safe policies and information. Best practice would suggest that you should be sharing it with your families as well. So whether that's through your public website or perhaps more just, when a family registers to your services, you're providing them a copy so that your families know what the expectations are and they're more likely to be able to spot if something is amiss. I guess your policies and procedures, if you are part of reportable conduct, should be explicit in that it should include information about the reportable conduct scheme and what that conduct is and what happens if an allegation gets made. All right, we're now going to move on to a bit of a joint case study about preventing and responding. So the second element of the reportable conduct scheme, as Jeff has mentioned, is about preventing and responding to reportable conduct. So Jeff, I'm handing back to you again.
Thanks, Gemma. So this outlines a situation that is not uncommon in terms of, it appears to be a situation where the employee who received the information wasn't sure of their obligations under the scheme. Essentially, a parent made a complaint to a staff member. The staff member requested that complaint be made in writing. That parent, for whatever reason, doesn't get round to making that complaint. And then 2 weeks later, a similar allegation's made against the same staff member, this time to the centre manager. And within that process, they become aware that there was this other allegation that was not explored. Now being hit by a staff member, a serious sort of allegations that can happen in this setting, but I think it does reflect that in many circumstances it's not unusual for an initial allegation to be quite low level and then for the next one to be escalated, not just in physical abuse, but unfortunately, as we've seen up in Queensland, there are employees that will test the system to see what they can get away with. Not that this is necessarily an example of that specifically, but I think it is an example that we should all turn our mind to, that somewhat low-level allegations can escalate, particularly if the person has some ulterior motives regarding what they might try to get away with. So this is an example where if we reflect back on Gemma's child safe standard that she has just gone through, we could look at what lessons might be learned from that scenario. So the first lesson is around leadership, governance and culture. So the head of entity must notify the Ombudsman about any reportable conduct. So in this case, the head of entity should have known about that allegation, or the first allegation. That employee should have passed that on. Now, why it didn't occur is most likely down to either a misunderstanding about what a complaint needs to look like. It appears that in that case, the employer had an understanding that it needed to be in writing, or that is not the case. Secondly, we'll look at a lesson regarding Standard 7, which is the staff capability and training. And as I just mentioned, it most likely looked like a case where that employee wasn't totally across their obligations under the scheme. It's possible that the individual centre may have had a policy that did require something in writing. So if that was the case, it would go back to Standard 1, and we'd have to have a look at what the policies and procedures were, and were they consistent with obligations under the Reportable Conduct scheme, or even other reporting obligations via SECA, etc. And another lesson learned is directly related to a child-focused complaint. Once again, allegations do not need to be in writing, keeping in mind that a reportable allegation, as per our legislation, is an express assertion that reportable conduct has happened. So in this case, the express assertion was from the parent saying that her child said she'd been hit. That is an allegation. And timely reporting most likely would have resulted, or at least reduce the likelihood of the second incident occurring in this case. Back to you, Gemma.
Thank you, Jeff. Yes, absolutely. Those are some great crossover, I guess, highlighting how, when you go and you do the standards well, it also boosts your ability to meet your obligations under the child safe standard, the reportable conduct scheme. So we're now kind of coming towards the end, and we do always like to finish off with some ideas and some examples of how an organisation can actually put the standards into practice. So the child safe standards themselves are flexible. So it's important when you're having a look at this slide to know that there isn't a right or an only way of doing the standards. But we have included up on the screen here some examples of what you can do for implementing those standards, and in particular we've kind of put some examples across standards 1, 6, 7 and 10. And the actions up here also are going to help you meet those obligations that you have under reportable conduct. So firstly, ensuring that you've got really clear information about how to raise a concern. So this might be up on your website so that parents, community members and staff, and even children and young people themselves, if you're delivering to an older cohort, they can actually see information about how they can raise a concern, including, as Jeff has said, the commentary that there shouldn't just be one, fill out this form. It needs to be clear that they can come forward and speak to somebody, and it doesn't have to be in writing. As I said just then, we always like to promote the idea of having more than one, even more than one written, particularly if you are thinking about how you can encourage young people and children themselves to come forward, making sure that, things like QR codes, if you've got, maybe teenage cohorts, schools in particular, this is a great way to encourage young people to kind of speak up. Or, as Jeff has kind of pointed out in the case study, making sure that your staff themselves are really aware about how they can keep their ears open for complaints and take those allegations and disclosures and then action them. We've mentioned many times today procedures and policies. So yes, absolutely document those procedures for complaints and reportable conduct, get them down in writing, make sure that your staff know what they say. And I guess supporting that, it's around the communication. So communicating both how to make a complaint, but also what happens next. So this is particularly important when we're thinking about supporting a young person or a child and their family through any process. So it's what happens next after the parent has told you that their child was hit. How are we keeping the parent and young person and supported throughout the process, and how are we balancing those requirements in terms of meeting our obligations under reportable conduct, providing procedural fairness to the person who the allegation is about, and also providing some level of transparency to our families and our children and young people so that they know that when they speak up, action happens, and it's not just, gone into the void somewhere never to be heard of again. You absolutely, in terms of communication, need to notify the Ombudsman of all reportable conduct allegations. And I'm sure Jeff will say that if you aren't sure if it is reportable conduct or not, you can always contact the Ombudsman to clarify. They will help you out. Of course, you've got to make sure that you're actually doing something when those allegations come in. So making sure that every single thing that gets raised gets reviewed and action gets taken. So whether that's a full investigation, if it's a allegation under reportable conduct, or whether it's more, training or other outcomes that might happen. Noting that even under reportable conduct scheme, not every allegation of reportable conduct would result in the termination of staff. There are often many other outcomes that will happen. But the important thing is that we are actioning it, and we are thinking about what do we need to do as an organisation to prevent the same situation from occurring. You should be keeping records of your allegations and complaints and disclosures. And this is important, as Jeff touched on in the case study, to consider in terms of trends. So, if we have had an allegation come in or a minor complaint made against a staff member, it might be treated, with a very brief review and, perhaps some sort of counselling or training to the individual. If we then are seeing more and more or further more serious allegations come on against the individual after we know that we have, provided them that training, then that's when we start to consider whether, the intent behind this person might be, they might be intending to create harm. So that's when, we use the history for that individual to think about their appropriate action. This is, I guess, really important because not only when we document and keep records can we make sure that we're treating an individual, we're making sure that that individual who is subject to complaints or allegations, is prevented from causing harm, but it also allows us as an organisation to look at, how is our organisation going as child safety? If we've had a number of kind of allegations or complaints come up which all relate to one particular thing. So for example, in the first case study that Jeff used, we saw, use of personal phones, taking photos, kind of staff almost accidentally finding themselves in a situation of crossing professional boundaries. If you've seen this come up a couple of times across your organisation, then it's a great indication for you to say, hey, we need to address this particular issue. So keeping those records and reviewing those records is a really good way to identify the action that you can take to prevent future harm. And then finally, of course, training. So training for your staff about child safety, what it is, why it's important, how to raise a concern, and of course, what reportable conduct is and what they need to do. Now, if you need more examples of what you can do and some practical actions ideas, there is resources available. So on the Child Safe Standards website, which is actchildsafe.act.gov.au, we've got a self-assessment guide, which can step you through the 10 standards and some examples of good practice and help you to identify the standards that you're doing well and standards where you might need to do a bit more work in. And we also have a practical guide, which is primarily aimed at staff and volunteers, so it's at that individual level, but there are some breakout boxes in those guides of what you can do. So really good place if you're looking for practical ideas and things to share with your staff and volunteers. There's also some really great resources already available on the National Office for Child Safety website, which relate to that complaints element. So if you're wanting more information about what a robust child-focused complaints process looks like, I encourage you to go and find that guide from the National Office for Child Safety. We are also working on a new fact sheet, which will support today's webinar, looking at most of the material we've covered today, so child safe standards and reportable conduct, and we hope to be publishing that very shortly, so keep your eye on our website. The Ombudsman and Jeff and his team also have some great web resources on their website. In particular, there is a resource kit, which includes a number of quite detailed fact sheets, particularly aimed at organisations, so outlining what those requirements are and what you need to do. And they also have an online e-learning module about reportable conduct that is free and very accessible. It's just right on their website. So if you're not sure what training or you don't have the capability to kind of develop something in-house, you can get your employees to go and do that e-learning as an option to ensure that they're understanding what the reportable conduct scheme is. Okay, so that brings us to the end of today's presentation, and we will move into some question time. We have had a few questions submitted in advance, so we're going to start off with those. So the first question, which is for reportable conduct, said, is consideration being given to sporting organisations, including private academies, to be included in the reportable conduct scheme?
Thank you, Gemma. Not that we're aware of is the short answer. The Ombudsman Act is a policy essentially owned by the Chief Minister of Territory and Economic Development Directorate. So they're the policy owners, and they do approach us from time to time with proposed changes to the legislation. So we are consulted, but not necessarily asked for what needs to be changed. So in this instance, the short answer is not that we're aware of, but any submissions or any feedback regarding the legislation should be directed to CEMTED. They have a policy team there that could consider a submission or some feedback that anyone might want to provide to them.
Thank you, Jeff. And we have, during today's webinar, had sort of a follow-up or similar question posted, which was about why Scouts and Girl Guides are not covered by the scheme.
We're not sure. It was modelled on the New South Wales scheme at the time, back in 2017. I know New South Wales have changed their scheme over time and had Victoria had a review built into the legislation. We did not, But once again, it would be a matter of, if you want to provide feedback regarding that, to contact CEMTED. But the explanatory statement from the initial legislation doesn't really shed any light on that decision either.
Yep, and I would probably jump in to say, particularly for Scouts and Girl Guides, you would be considered covered by the child safe standards, absolutely. And just because you're not covered by reportable conduct, really you can still do everything that is required by reportable conduct except telling the Ombudsman. So, having those procedures and processes in place, doing robust complaint management, making sure that you're investigating and having that kind of head of entity taking responsibility for allegations coming in, all of that falls under best practice for the child safe standards. So whilst you're not covered by the reportable conduct scheme, you can, as an organisation, and should take action under the standards to make sure you are having that really great, robust process for child safe complaints. Okay, our next.
Sorry, Gemma, I might just add, we do meet, you just mentioned the National Office of Child Safety before. We do meet with them as an interjurisdictional forum. So all the reportable conduct schemes around the country meet twice a year. And NOCS National Office of Child Safety, have indicated a desire to harmonise the schemes, which would, in a perfect world, eliminate these differences between the schemes to have them more aligned. But I would suggest that would be quite a long game. But there is a recognition that the schemes do differ from jurisdiction to jurisdiction.
Yeah, fantastic. Great call out. And we know that there are differences that exist in terms of, working with vulnerable people requirements as well. On the plus side, the child safe standards are consistent with New South Wales. So for organisations who are working, cross-border here in the ACT and New South Wales, if you are doing standards for ACT and New South Wales, they are the same. You don't need to duplicate. All right, our next question was quite long, and I didn't want to change it too much from as it was submitted. So if you are the person who put this and I am not answering your question correctly, please, if you are comfortable to do so, post into the chat. But this question says, if a report is made by a third party, for example, a social worker or a health professional, about something a client told them, does the person subject to the report, that's the alleged perpetrator, get information that would identify the alleged victim? So I think what that's saying is, if a person tells you about potential child abuse that they are aware might be being perpetrated by somebody working for your organisation or another organisation, what happens with that information, and what does the perpetrator get told when a reportable conduct allegation is made against them?
Thanks, Gemma. Not necessarily would be my first response to this question, particularly regarding what's included at the end of the question regarding any safety concerns regarding that information being fed back to the alleged perpetrator. For the reportable conduct scheme, we do have a focus on procedural fairness. So if we can see that procedural fairness has been not given as fully as it could have because of this aspect, we might provide that sort of feedback to the designated entity, but with recognition that there was some exceptional circumstances in place regarding the safety of most likely the child. So a slightly different lens from what we might, or what I know of, mandatory reporting through children, youth and families, where it wouldn't necessarily be an investigation regarding significant risk of harm to a child, but this could also be something that has to go to the police. So that would be a different circumstance as well. But in terms of reportable conduct, we would view it through procedural fairness. Can the alleged perpetrator give an informed response to an allegation without this information being known to them? that would be something we need to consider, but with full acknowledgement that the safety of the young person would have to be front and centre of any feedback or decision that might be made around that.
Thank you, Jeff. And probably just a clarifying question to support that. Does the reportable conduct scheme, so the Ombudsman, communicate directly with, you know, an alleged perpetrator or a subject of an allegation, or is it always done through the organisation for whom that that subject works for?
We would not contact the subject of allegation directly regarding the investigation. We can take complaints about how an investigation was handled. So in those circumstances, we would contact or be in contact with the alleged perpetrator, but it wouldn't be regarding directly being regarding the conduct of the investigation. In terms of this office taking investigative actions, it would be more so responding to the complaint that the alleged perpetrator has regarding how the investigation was carried out. So it wouldn't be through, in this context, that we would make a decision about providing that information or not. It would be more so around taking information from an alleged perpetrator about the conduct of the investigation, and they could make a complaint to our office about it. And that may well be that they weren't informed of who the alleged victim was, and they feel that didn't provide them procedural fairness. And we'd have to look at each matter on a case-by-case basis if that was what the complaint was about.
Thank you. All right. And then the final question that we have up on the screen there is, what category of reportable conduct poses the most prevalent risk to children in the ACT?
I will interpret this question as what is the most common category that we see in terms of the notifications we receive. It will be around the ill treatment of children, emotional abuse, and hostile use of force. So they're two subcategories of the overarching category of ill treatment. I don't have the annual report in front of me, but I would suggest that ill treatment of a child, both emotional abuse and hostile use of force, would capture possibly 50% of the matters we see. But I can respond to that, giving a more detailed answer by going through the registrations and responding to that person.
Yep, thank you. And I think, you know, in terms of what's most risky, obviously reportable conduct and the child safe standards are designed to prevent harm and abuse in all of its forms. So we try not to say, oh, this type of abuse is, you know, this type of abuse is better than another type. But of course, you know, we do have, you know, perceptions and, you know, understanding that, you know, things like child sexual abuse and physical abuse are, you know, of course, very, very damaging for children. So those are generally, you know, what we would consider the, you know, highest level of seriousness in terms of a risk category. All right, it is 1:59. We have had one further question pop into the chat. So this one says, if an ACT public service employee makes a reportable conduct report regarding historic conduct of a religious figure, presuming that the religious organisation isn't aware of this report, who would be doing the investigation?
The default is the current employer of that person. If that person is if that person is still an employee of a designated entity. It can get tricky when the designated entity that the matter's actually in relation to isn't the person's current employee.
Yep. And I think there's probably broadly just a question in there about historic allegations. Where do historic allegations sit for reportable conduct, Jeff?
They are captured by the scheme if they've been reported after 2017 and the designated entity was not previously aware of the allegation. So we do have matters where historical, usually sexual abuse claims are made, but if it is the case that that designated entity did already know about that allegation. It is not covered by the scheme, but if they do become aware of it now, and what we see, or how we see this process play out on the ground, is that it's usually via a national redress scheme application that they become aware of. Once they become aware of that allegation, what we're calling historical matters, they are covered by the scheme, that allegation.
Fantastic. Thanks, Jeff. That's a great answer. And yes, I know this has come up in our other webinars, but we haven't talked about redress today in our overview of the sort of child safety landscape, but the National Redress Scheme does relate to historical childhood sexual abuse. So if you or you're somebody you know or a client does come and report historic child sexual abuse to you and you're not sure where to go, the National Redress Scheme is a great place to start for support. So I can make sure that that gets included in our reference pack on this presentation at the end. Right, I think that is it for our questions, which is just as well because it is 2:02 p.m. So just wanting to say thank you to everybody for your attendance today. Our contact details are back out on the screen, so make a note of those if you need. You are welcome to contact us if you have any questions, or if you have a question or you didn't quite get around to posting it into the chat, you are welcome to send it via email to either of our teams. We also have a little kind of satisfaction survey about today's webinar and the child safe standards. We encourage you, if you are able, to take a little screenshot of that QR code and fill in our survey. This helps us to know what we are doing well and what we can improve. Our team at Child Safe Standards does have one further webinar coming up, which might be of interest. So our introductory webinar, which just gives a bit of an overview of what the Child Safe Standards is, and a little bit more detail about the 10 standards and things like child rights. That is happening. We've got an evening session coming up, and I know that there was quite a lot of early childhood on the call today and religious organisations. So if you haven't yet had a chance to pop into our introductory webinar, the evening session is running on, I think, the 30th, but I'll make sure to include that information into the follow-up email. We also do have plenty of other resources on our website, as does Jeff, and we have a survey which tracks how organisations are progressing with the implementation. So that survey link will be posted out to you via email, which should be coming out in the next day or two. So again, we welcome you to fill in that survey because it allows us to shape, what our webinar topics are. Again, I'd just like to say thank you to everybody for attending today, and please contact us if you need any further help or questions answered. Thank you.